G'day everyone and welcome to another episode of Spurling Insights. My name is Dicky Abraham, Principal Lawyer at Spurling Legal.
And I'm Dania Foo. I'm Dicky's wife and I'm also a lawyer at Munro Doig Lawyers.
Welcome Dania, back for another episode.
Yeah, here we are. Episode 2.
Before we get into it, let's get the usual disclaimers out of the way. So everything we say or do in this episode shouldn't be construed as legal advice. It's just two lawyers having a yarn about law, life and everything in between. Now, with that being said, back for episode 2. We're not a one-hit wonder, so to speak.
No, but before we dive into the episode, would you want to share with everyone what the feedback was like from our first episode?
Yeah, sure. Look, the feedback has been largely positive and I'm pleasantly surprised. As you can attest, I was quite nervous.
We both were.
Yeah, that's right. But it's been good. A lot of my colleagues who have seen the episode have got back to me and wanted to know more about how I use AI, specifically what sort of programs I use, how I use it, and what sort of safeguards I've implemented so I don't end up being the leading authority on how not to use AI.
No, we don't want that.
So I thought this would be a good opportunity to go through that and explain in detail how AI is embedded into Spurling Legal and the different programs we use and how they work together. What do you think?
I think that sounds really good.
And then obviously you also want to discuss the working from home commentary and dialogue that's been around. So we'll have a brief chat about that.
Yeah, and that may be particularly interesting for our listeners in Victoria.
Yeah, I think so, especially because in Victoria there's a push to try and entrench a right to work from home. At the moment there's a right to request to work from home, but there's no real right to work from home. So we can have a discussion about that. So shall we get started?
Let's. Now, you've got quite a few different AI tools. Which one would you like to start with?
Let's start with Sophie, my AI receptionist. But before I talk about that, for context, I have 5 different AI programs that I use. There's Sophie, there's a legal AI assistant that I use, there's Fireflies, which is an AI transcription service that I use, and then there's an AI time tracker as well that I'm looking at. And last but not least, I also have a standalone AI running on my computer. And all of them work together. But start with Sophie. As Dania mentioned, Sophie is my AI receptionist. She's exactly that. She does everything that a receptionist can do. She's the first point of contact when you ring Spurling Legal. She's fantastic. She was developed specifically for Spurling Legal, so I got developers to develop her for me. She is able to answer calls, triage calls, or take messages. Basically everything a receptionist can do. She's fantastic. I was hesitant at first because I wasn't quite sure what to expect. But because she's been developed specifically for Spurling Legal and the parameters I've set, I think she works really well.
Did it take a while to get her trained up?
Yeah, it was about a month. So it took me and our developers about a month to get her to a position where we could deploy her. She's not that expensive. Right? It's a subscription-based model, so I'm paying $200 a month for her. Much
less than what you'd pay a human to do that
job.
That's for sure.
Correct. So she's quite good in the sense that, unlike a human, she's been designed to try and grab certain details of clients. That's what I wanted, because as a one-man operation, often I can't get to the phone if I'm in court, if I'm with another client conference. So I want her to make sure that she captures certain details so I can get back to them. So she's been designed so that she tries and pushes for those details in a very polite way. Of course, if a client says, I don't want to provide my phone number or my email, she will immediately say, that's fine. We'll get Dicky to call you back or contact you or would you like to contact Dicky when you get the chance. So she's incredible and she's continually improving. So each time she gets a call and she answers the phone, she learns from it. So, and then soon in the next couple of months, she's gonna, as I understand it, our developers are gonna deploy a calendar integration, so she will be able to review my calendar and book appointments if there's a slot available, which I think will be quite handy for myself, because at the moment she's taking messages or she's directing the call to me and I'm manually booking the slots in the calendar.
Now, I've spoken to Sophie a few times and there is a slight lag in answering questions that normally a human wouldn't necessarily take that much time to think about that particular question. But besides that, I couldn't really tell that Sophie was not a human. She speaks like a human would in terms of the cadence of her voice, the language she uses. So have you had any feedback from clients, or have you had anyone identifying that she's not a human?
Yeah, look, most of the clients don't recognize that she's an AI receptionist. They often, and I've got a portal where I can see the conversation. So often I can see how they're talking, and it simply comes to me. The ones that do recognize that she's an AI assistant, they immediately ask to be put to a human. So then the call comes directly to me, and the first question they ask me is whether I'm an AI. So I don't know whether that means that Sophie's doing such a great job of impersonating a human, or I'm doing a pretty poor job of being a human.
No, I won't make any comments about that point. But anyway, so that's Sophie. So shall we move on to the next AI tool?
And this is probably my favorite tool to use. It's the Legal AI assistant that I've subscribed to. It's an LLM, or a learning language model, that's been designed for lawyers in Australia and New Zealand. It's a fantastic piece of kit because, and the name is quite misleading. Even though it says even though it's named Legal AI Assistant, it's probably on par in terms of skill level and legal expertise with a 4 or 5 PQE lawyer. So I treat it like a grad. I ask it to draft chronologies, draft letters, and then I settle it. And the quality of work that it produces is incredible. I can't say enough good things about it. So it's my favorite tool to use, and it does make a lawyer's life a lot easier.
Now, when I've used more generic AI tools out there, so for example, ChatGPT, I find that the quality of the answers that I get back really is so dependent on the quality of the prompt that I put in. And sometimes, I suppose that's a failing on my part, that, I'm not putting great prompts in, or I'm having to spend a lot of time refining those prompts, crafting those prompts, and it's very time consuming. So do you think that, given the amount of time that you need to spend on producing these quality prompts to actually produce an answer that you're looking for, it is worth using the AI tool compared to just doing the task manually?
Oh, absolutely. With the Legal AI Assistant, I dictate to it. And you have to keep in mind that the Legal AI Assistant, it's a packet of programs. So it's a packet of LLMs. So they have an LLM for discussion purposes. They have an LLM for research purposes. And they all work together. They recently rolled out an LLM for prompts. So they have an LLM where you can dictate what you want, and it will fashion that into a prompt with the appropriate context and detail. And you simply click that, plug that into the discussion model, and it generates the response that you were seeking. So yes, if you were to manually type out the prompts, it might take a bit more time, but I dictate. And that's where the time saving comes in, because you're dictating. And Compass, which is the LLM model that fashions the prompt, that's what it's called.
Yes.
It immediately goes through and fashions your colloquial language into a prompt that you can plug into the discussion model, and then it generates the answer.
And it probably fashions it in a way that the tool itself has been trained to answer, so you're really getting the best prompt for that tool.
Correct, exactly. And so with Compass, it makes a lawyer's life a lot easier, because often, like you correctly observed, getting that context to the AI is very important. And you can use, it's akin to working with a graduate lawyer as well. You tell a graduate lawyer to draft a summary without giving him or her too much context. You'll get a summary. Now, if you give him context, you will get a better quality summary. It's the same principle. So providing that context is important, breaking it down into different tasks as opposed to one giant task. And that's where the Compass learning language model comes in. It breaks it down to various different tasks. It asks for more detail if it senses that there's something missing, and then it fashions that into a prompt for you, which you can plug into the discussion model, and then your answer will be generated. So it's that packet of programs that work together in legal AI is very powerful.
These days, there seems to be an increase in the uptake of AI tools in legal practice, but there's still a lot of concern and caution with using them in legal practice, because whenever we tend to hear about lawyers using AI tools, it's usually because they've landed themselves in some hot water, in that they've relied on cases or legislation that an AI has just hallucinated, and they've relied on that. So does Legal AI Assistant have the capability of producing hallucinated information, and what are the safeguards in place, if any, that you use to ensure that you're not one of those cases?
So Legal AI is still an AI, so it does hallucinate cases, but as I said before, it's designed specifically for lawyers in Australia and New Zealand. So the fact that it's designed for lawyers in itself reduces the amount of hallucinations. Secondly, the way it generates its answer really does help eliminate that problem, because every time it generates an answer, it provides footnotes for all the cases or legislation it's referred to. So there is a link at the bottom with the case or the particular legislation it's referred to, and you can click the link and it will take you to the web page. If it hallucinates a case, and this is my experience, often that link doesn't exist, or that link is not necessarily there. So that's immediately a red flag. So you'd obviously pick that up straight away. Again, I go back to working with a graduate lawyer. If the graduate lawyer produces a piece of work, you're not going to accept that piece as it is. You're going to scrutinize it. You're going to make sure the footnotes and the references are accurate. So you will check it. It's the same principle. And it makes it easier. You don't need to go and actually search the case. The link is there. If the link doesn't pop up, then you need to interrogate that case, or explore that a bit more and make sure it's not a hallucinated case or a piece of legislation. So Legal AI is quite good that way. It makes it easier. That doesn't mean that it does not hallucinate material, because it's still an AI. So you just need to be diligent about it. And if you check the references and if you go through and check the footnotes, it shouldn't really be a problem.
And the other big issue that lawyers tend to be concerned about is confidentiality. When you're plugging things into something like ChatGPT, that's not confidential at all. So you've got to, make sure that you're not putting in confidential information and those sorts of things. Is that the same for Legal AI Assistant? Do you need to go and anonymise everything that you're working?
Oh, no, you don't need to. I don't anonymize anything that I'm working, any matters that I'm working on if I'm putting it through Legal AI. Legal AI does not use your data to train its models. The developers use their own data. So they're not using your client data to train the model. Secondly, it is ISO 27001 certified, and it is also SOC Type 2 compliant as well, which are apparently the two highest ratings you can get. I know most of the practice management software are compliant with that sort of security ratings.
So it would be like akin to putting information into your practice management system.
Exactly. You're not waiving confidentiality or privilege when you upload a document to Clio or whatever practice management system that you're using. So it's the same principle here. Legal AI Assistant, the director was actually interviewed by the Law Institute Journal in Victoria, and there's a great article where the director sets out exactly how it operates. So for any of our viewers who is interested in that, by all means, please. And it was a recent edition as well, so by all means, feel free to check that out, because it sets out exactly how it operates, and it directly addresses these concerns. It's a fantastic piece of kit. I can't recommend it highly, and I'm not quite sure why it hasn't taken off, because to me, it seems like the value for money it provides is incredible.
That's great to hear. I know that in my practice, that would certainly be very helpful.
I suppose the question is, for a solo practitioner like me, yeah, it's easy to deploy that, but when it comes to scaling it up for different firms and multiple licenses, it might be more expensive. But again, to me, the value it provides far outweighs its cost.
So shall we move on then to your next AI tool?
Sure. The next AI tool I use is called Fireflies. It's an AI transcription software. It attaches to all my conferences, all audiovisual conferences, so Zoom, Microsoft Teams, whatever platform I use. It records everything I do, or everything. It records the whole conference, generates a transcript and also generates a summary, a very detailed summary with action items. If I was to have a conference in person, I turn it on my telephone or on my mobile, and it will do the same. It will record it and it will generate a transcript and a summary. The reason I like Fireflies so much is because compared to some of the other software I've trialed, its accuracy is incredible. It is able to pick up spelling and various other grammar and everything else much better than other software that I've trialed out. So I really like it, A, because it's accurate, and B, because I'm able to, there's no real confusion over expectations.
Yeah, I mean, when you think about the fact that in a conference with a client, there's usually a lot of information for the client to digest, to retain that information, and, you know, there's usually action points for one or both of you to do, and for a client to remember all of that can be challenging. And oftentimes, you know, lawyers might then have to go back to their desk after the conference, type out an email or a memo or something along those lines to then send to the client, reminding them of what was talked about. I presume that if Fireflies is producing a summary, you could just send that summary off to the client without having to do any additional work after that conference.
Exactly. And as you can attest, when you attend a conference, you're making a file note of the conference, but you're not capturing everything in that file note. You're scribbling down notes. You're trying to process information. There's obviously things that you miss. That doesn't happen with Fireflies. It captures everything. It generates a summary, and it also generates action items for each party in the conference. So you're able to send that to the client straight away, and there's no real confusion over what's expected of the client. The client knows exactly what's expected of me. So how many times, and you could probably say something about this, how many times we as lawyers sought documents from clients and they've sent the documents but not all of it, and we've had to go back. I found that by using Fireflies in my practice, clients have a file note essentially where they can refer to it straight away, and they know exactly what they need to respond to after the conference. So there's no going back and forth. I found that the instances of me going back and forth with clients is far less compared to what I did prior to Spurling Legal. So in that particular regard, it's quite good because you're managing everyone's expectations, and it's a really easy tool to have.
Yeah, and it probably helps with client satisfaction as well, because the client's then not going to, as you say, have to go back and forth with this, and it's not delaying you working on the matter.
Exactly. So it helps with efficiency, it helps with managing client expectations, because as you know, a file note in itself is not in a form where we can send it to a client. It's a note scribbled by us. If we were going to send it to a client, we're going to have to refine it further, make sure it's in a form that we can send it to the client. With Fireflies, you already get that in the summary, so we can send it through straight away.
It seems like such a simple tool.
It is,
but very effective.
It is, and I mean, if firms are transitioning to using AI, this is probably the first tool they want to start with, because it eliminates the need to take file notes essentially. And file notes are powerful pieces of contemporaneous evidence. You know that, I know that. It eliminates that human error from that particular aspect of the job. So, and it's not expensive. Fireflies, I pay about 35 Australian dollars or something like that a month. So it's pretty reasonable in terms of price. So if firms are looking to transition to AI or using, and they don't know where to start, this is probably the first sort of program they want to look at, because it does assist in managing those client expectations really well.
And is it able to integrate with your practice management system?
Not yet, because Fireflies is not just catered for the legal industry. You can use it as an accountant, you can use it for any industry really. It does integrate with certain software, but not necessarily legal practice management software. So I simply download the summary and place it on the file. It's a drag and drop. It would be great if it did, but you know what, you can't have everything.
No, you can't.
And the last tool now I think we want to discuss is the AI time tracker, which I've I've trialed a few, and I'm still working on settling on one. But essentially, it just tracks what I do on my computer. It tracks the task that I'm doing. It generates a summary for that task, and it generates a detailed narrative as well. That's what an AI time tracker does. So
lawyers who time bill, and most lawyers bill based on time, practice management systems generally already have like a timer, right? So when you start on a task, you turn the timer on, you do what you need to do, and then you turn your timer off when you stop. Then you essentially go in and just type out, drafting letter of advice to so-and-so regarding such and such, and you just put in how much time you've spent on the matter. Now, that just doing that in itself, with that amount of detail, doesn't generally take up an enormous amount of time. It could be a 30 to 40 second exercise. So given that a tool like that already exists in a system that the firms already pay for, do you think the benefits you get from having an additional AI tool that does that outweighs the costs?
Oh, absolutely. I think it definitely does, because how much detail can you put? How much detail can you insert in 30 or 40 seconds? So you often get time entries where it just simply says email to so and so regarding so and so, and that's it. It doesn't have any further detail. With the AI time tracker, it tracks exactly how much time you spend on a task, and it generates a detailed narrative for that task. It is able to recognize that. Let's take the example of if you were to draft an email to a client regarding a potential issue, and you refer to case law while you're drafting that email. So you went and opened up a web portal or a web page, looked at case law, you looked at legislation, and then you've referenced that in your email. An AI time tracker will intuitively track all of that and realize that that particular email involved work which related to researching the law on this particular issue or on this particular case, and also this particular legislation, and it will incorporate all that into the narrative. So it won't be just drafting an email to so-and-so regarding so-and-so. It will say, drafting an email to so-and-so regarding so-and-so, considered this particular case, studied this particular legislation, formed an opinion, and then you get a detailed narrative for that particular email. So that way, I think it's quite powerful, because when you have such detailed time entries, the scope for dispute is minimal, because if you spend 10 minutes drafting an email, and a lot of that time was trying to research the law and various other pieces of legislation or cases in relation to that email, then the AI time tracker will reflect that in the narrative.
I think that's a good point, because what you type in the narrative is what appears on the bill, and the client sees the product that they receive, this email, and I think sometimes clients think that, I'll shoot an email to the lawyer. They probably know the answer off the top of their heads, and they can just shoot an email back. But they don't necessarily see what goes into producing the email. So it's considering the law, looking at all the documents and all the rest of it, and all they see is just this 2 or 3 paragraph email, and go, why did they charge me that much for it? Exactly.
And that's exactly the point with an AI time tracker. Whether you spend 2 minutes on an email or 10 minutes on an email, then the narrative is going to be the same. It's going to have that detail. It'll explain exactly what happened in that time you spent drafting that email. The other benefit of the AI time tracker is, if you have panel clients, for example, you can provide the particular agreement that you subscribe to as a panel client to the AI, and it will draft the time narratives in accordance with that agreement. So it intuitively learns how you like to draft the narrative, and then it will provide suggestions so that it complies with the legal agreement that you're subscribing to. So let's, for example, if the agreement says you can't You can't use the term review or study. It will provide suggestions. It will say this does not comply with your SLA. So you will have to and provide recommendations, i.e. change it to analysed or considered. So that is quite handy and quite powerful for lawyers who have panel clients. Look, it's a fantastic tool to have, and again, it's one of those things where if you are a law firm looking to transition to AI, do you need it? Like you said, probably not, but it will make life a lot easier.
Yeah, and I think, especially when we're not necessarily required to provide that kind of detail on the bills.
Exactly.
I guess, sometimes I wonder whether that's what clients want. Is that what's been your experience in clients' feedback when they see this bill with such detail on it?
Look, my clients really like it. I've had one client who used multiple lawyers, and the feedback I got from him was that it's great to see that detail, because he often queried why he's getting charged half an hour for an email, and he looks at the email, and yes, it's a substantive email, but does it take half an hour to draft that? But now he looks at it and goes, right, I understand what's involved in drafting that email. So he was quite pleased to have that feedback, because he had the story, the narrative. But then again, it depends on the clients as well. So some clients might just like the one-line entry. The clients I have and the feedback I've received have been that it's good to see that narrative. And I think the more detail I have, the less likely there is going to be a dispute about it. So,
and of course, as a litigator, that's what...
That's right. My life revolves around disputes. So I want to try and eliminate any disputes relating to my bills. And the best way to do that is to be as transparent as possible. But yeah, so it's a great tool, and I really enjoy using it. Is it necessary? Probably not. But the way I practice, I think it really adds value to my practice. The last tool I use, and it's not really a tool, it's just a standard AI that I run on my computer. It's basically there for me to be able to anonymize matters. It runs just on my laptop. Everything I do is saved on my hard drive. The obvious disadvantage is that because it's running on my laptop and using my memory, it slows the computer down a bit. You don't get those responses like you do instantly when you put it into illegal AI or various other models.
And so are you only using this for purposes of if you need to put information to ChatGPT, for example?
Yeah, pretty much. I rarely use ChatGPT. The only times I use the AI that's running on my computer is for prospective clients. So if a client has a prospective inquiry and they send through, court documents or an order or something along those lines, and I need to get some information, I don't necessarily create a file on Legal AI. I don't create a file on my practice management software until they sign a retainer. So in those circumstances, if I need to use an AI, I will anonymize it using LM Studio, and then I will use, one of those generic models that are out there. So if that's if I need to use it. The instances are few and far between these days. Because I've got Legal AI, I tend to rely on it quite a bit.
Yeah. So now we've talked quite a lot about how these different tools work and how you use it individually. When you were thinking about all of these different tools and what was the best tool for the task, was that the only consideration you had, or were you approaching it more from the perspective of, this is how I want to practice, what tools do I use or are available for me to be able to practice the way I want to?
Well, it was the latter, and it's because I had a very specific way I want to practice. So the Spurling model of cost, which I designed, is premised on the fact that there is cost certainty, there is cost transparency. In order to implement that model, I needed these systems. So my model doesn't work without one of these systems. Let's take the example. If the AI time tracker isn't there, my bills don't have that detail. If Fireflies isn't there, I'm not able to send the summary to the client, and I'm not able to use the transcript and feed it into Legal AI and generate a response and a game plan. I have to do it manually, which takes time. So my whole model is based on all these systems working together in harmony. So I started from the premise that I needed these items to make the model work, and then I researched what sort of software is available. And I'm still doing it because I haven't settled on an AI time tracker as yet. I've trialed a few. Some of them are quite good, some of them not so good. But I think I will be settling on one very shortly, because it's quite good.
In law firms, the heart of running a law firm usually revolves around the practice management system. All of these different AI tools that you've talked about, not all of them seem to be able to integrate with your practice management system. How important is that for you, if at all, that the integration with your practice management system isn't quite there yet? Is that important, or is the integration in the sense of how the different AI tools and your practice management system is able to work alongside each other but cohesively, is that more important?
Look, for me, it's more important that the software and the systems work together more cohesively than integrating with my practice management software. It will be an added bonus if all of them did. It will be even better if there was a practice management software that had an AI legal assistant, that had a transcription service, that had an AI time tracker. I would sign up for it straight away.
Well, sounds like there's a gap in the market there.
But there isn't. So for me, what is important is that these systems work together to try and help me implement the Spurling model of costs. It might be different for another firm. They might want something that works with their practice management software because they're not a new firm. They've already got their systems in place, so that takes priority. So it's up to each firm or each individual, really, what they prefer. I suspect newer firms, or if you're starting a new practice, you would want your systems in place, and you'd choose. You would favour having various systems cohesively working together, as opposed to each of them integrating with your practice management software. Existing firms, on the other hand, might prefer the other option, where the practice management software is central and everything has to integrate with that, because that's how all their lawyers work. That's how they've been trained. It'll cost quite a bit to retrain people with a completely new system. So I think it's quite subjective. I think it depends on each firm, to be honest.
Now, we've talked a lot about AI. Was there anything else you wanted to say before we moved on to the work from home case and work from home law?
No, I think we've covered that quite well, and I'm hoping that I've answered the questions that my colleagues posed to me in the feedback from the first episode. But I think I don't think I have much more to say on that, other than the fact that all these systems, it's not necessary. You don't need everything. You don't need all the bells and whistles. You can, like I said, start with the most basic AI system, which is something like Fireflies, and build to it. But if you're a newer practice, or if you're looking to practice on your own and setting up a new practice, then perhaps you might want to do a bit of research into how you want to set up the way you want to practice.
It sounds like, for new firms especially, that you'd be able to offer a lot more in terms of service to the clients with fewer personnel,
yes,
and fewer employees. Now, whether or not, obviously, that's a positive or a negative thing in terms of a skill set of young lawyers out there, and being able to train up in a firm and those sorts of questions, I think that's probably not within the scope of today's episode. But it's I think a concern.
Yes, I think so. And look, we've covered the AI issue quite well. But shall we move on to working from home? Because I know you're keen to get onto that. Did you get a chance to read the case that I sent to you, Collins v InterSystems Australia Pty Ltd? And for our viewers, the reference is 2025 FWC 1976. Did you get a chance to read that?
I did get a chance to read it, yes.
What did you make of it?
Look, before I properly read the case, I thought that I didn't really like the decision very much. I didn't like the outcome. Collins had requested 2 days working from home because he's got school-age children that he said he needed to care for, and I thought, well, that was a pretty reasonable request. And for it to be refused, I thought was a bit harsh. That was my initial thought. And then when I actually read the case and read what the law says, my views changed.
And what does the law say?
So what I didn't know, and I must say I'm not an employment lawyer over here, but what the law says, and this is the Fair Work Act, is that employees, and not all employees, but employees generally do have a right to request flexible working arrangements if particular circumstances apply to them, such as having the need to care for young children. And if you set out that request in writing, and if you're able to set out why your request for working from home arrangement is necessary due to your circumstances, then your employer can only refuse your request if there are reasonable business grounds to do so, and after they've tried to come to compromise with you.
Exactly. And look, I shared the same view as well. When I initially read the case, and I only had a cursory review of the case, I didn't read the entire case, I thought the decision seemed a bit harsh because Collins was mandated to go back into the office 5 days a week. He requested to work from home 2 days a week. That request was rejected by the employer, and the Fair Work Commission sided with that. I thought that was a bit harsh, but then when you read the decision, it's quite clear that the Fair Work Commission had no option but to make that decision. The evidence that was available meant that that was the only decision the Fair Work Commission could come to.
And poor Mr. Collins, I mean, really, I think he if he had set out in his request why he needed that work from home, not just why, but how that 2 days working from home would assist him with his parental responsibilities, I think perhaps that might have been a different story. Or at least partly, at least that would have been a valid request.
Yeah, I think so. And I think the fact that the employer engaged in a dialogue with Collins as well, they wanted to try and accommodate this, but they couldn't. They tried to offer flexible arrangements for him to pick up his kids from school from memory, and he rejected that. So it wasn't quite clear to the Commission why he needed to work from home to care for his kids. He didn't articulate that well enough. So I think that's where it fell through. The timing of the decision is curious because, as I understand it, and this is my memory, the decision came out a couple of weeks ago before Victoria decided that they wanted to try and create a right to work from home as opposed to a right to request to work from home. So the timing is a bit curious as to whether one led to the other. We don't know. But if that right existed, then Collins would have been able to work from home. He wouldn't even have to make the request. He would have had to just tell his employer, I'm working from home 2 days a week. What do you make of Victoria's push there? Do you have a view on that?
Well, look, I think employees would absolutely favour it, of course. I think that works in their favour. But, the commentary around Victoria passing that law has been quite interesting because, from what I've seen, all the commentaries around, well, does the state even have the power to actually pass such a law?
Correct. And the issue really is conflict, isn't it? Because all laws regarding employment is governed by the Fair Work Act. That's the Commonwealth, or that's the federal jurisdiction. Now, Victoria is trying to enact a law, and that obviously comes in conflict with the federal jurisdiction. And as you know, if there's a conflict between state and federal law prevails. So it'll be interesting to see how Victoria gets around that particular issue. But I think they're trying to get around it by saying it's an anti-discrimination law, aren't they? Look, yeah, I think that was suggested from the commentary and dialogue. I think we'll just have to watch the space because I'd be curious to see how they get around that particular issue. Yes. We're not constitutional lawyers, so but it is interesting because if they do manage to get around that issue, I suspect it will follow across the other states potentially. But yeah, look, interesting topic in terms of working from home. And as you correctly pointed out, not a lot of people might not realise that you have a right to request to work from home.
No, I certainly didn't before I read the case.
I was aware of it because I've dealt with employment disputes, but I'd imagine if you don't work in the employment space, you wouldn't know.
No.
So I suppose it's good to educate people about that as well. Anything else you want to have a chat about? I think we've spoken enough for this episode.
I think so.
All right. Well, thank you for joining us on the second episode of Spurling Legal. If you have any questions regarding this episode, feel free to get in touch. My name is Dicky Abraham, principal lawyer at Spurling Legal.
And I'm Dania Foo. Thank you for joining us, and we'll see you next time.